It is my pleasure to introduce Samantha, who is a trust and probate litigation attorney. After graduating from Chapman University, Samantha studied law at California Western School of Law in San Diego before passing the California Bar in 2014 and NV Bar in 2015. Since then, Samantha has become a partner at her firm where she helps families navigate the sometimes confusing process of probate. Help me welcome Samantha Smith.
Thank you, Josh. So today I wanted to present on inheriting real estate after Prop 19 changes. Proposition 19 was passed in late 2020. We all voted on it, and then it became effective in early 2021. And Joshua and I, who's our life insurance expert of the group, we're talking about how life insurance, the product of life insurance, can help hedge the burden of increased property taxes post Proposition 19. So I'm going to go into what Proposition 19 is, the benefits of how it used to be and how it changed, and give some examples, and then also examples of what can go wrong if you don't plan properly. So next slide, please. The first, this is our team here at NM Law, and thanks to John's wonderful composite photography, we all look wonderful in this group photo. So we have, I think we're up to 4 attorneys now and about 6 support staff. So now we're up to about a team of 10. So if you or your referrals retain our firm, then you always know that you have like this team approach, and we're always here to answer questions and provide answers right away. And so the general rule with property taxes, right? Proposition 19 affects property taxes, and everyone here in the state of California, the goal is to pay the least amount of property taxes as possible. So the general rule is when property is transferred, property taxes are going to be reassessed unless an exclusion applies. And this is like an exclusion to reassessments. Here's some common examples. It's from parent and child. It goes both ways, from child to parent, parent to child. Same with grandparent and grandchild, goes both ways. Husband and wife are registered domestic partners. And proportional interest transfer or into a trust. So proportional interest transfer would be, for example, husband and wife transfer, they each own a 50% as joint tenants, and they're transferring into their trust where they're both equal beneficiaries of their trust. So in those situations, property taxes will not be reassessed. And next slide, please. So transfers between siblings, there's no applicable exclusion. The property taxes are always going to be reassessed for transfers between siblings. So this comes up a lot in our trust administrations, where a trust says, split my assets equally between my kids. And one of the children may want to keep the home and the others want, just the cash, right? They'd prefer the house be sold just so that they get the distribution. So I'll talk about some ways that we can plan around the result of having property taxes reassessed when there's only one house to split and a couple children to divide among. So benefits of Proposition 13 before 2021 changes. So Proposition 13 has been around in California for a long time, and it's been changed throughout the years through various amendments. Property owners, so prior to the changes, property owners could pass on their real properties to family members, including vacation homes or commercial income properties. So, this is not their primary residence, and retain the low tax basis. Just because it was a transfer from parent to child, it would qualify. There was an unlimited amount for the principal residence, plus the $1 million lifetime limit for other real property. So your principal residence would go automatically and not be reassessed if it passed on to children. And then you could also pass on up to $1 million of other property, your commercial properties, your vacation homes, or second homes. And the benefit was that you're keeping property tax bases significantly lower than present property values for an endless number of generations. So, for example, if somebody bought a home in 1920, right, for $50,000, and now that house is worth $5 million, as long as before the changes, the people who inherit the property now or own the property now worth $5 million, they could still be paying a property taxes that are, started at the $50,000. They can increase up to 2 to 3% per year. Next slide, please. So Proposition 19 came about, and it definitely was a fairly big change. Like I said, it was voted on in November 2020, and then it started being effective in February 2021. So now it must be a principal residence. The property that you're passing on must be a principal residence, and in order for the exclusion to apply from parent to child. The family homes and farms only. Farms is kind of funny. It's like not very many times we are transferring farms here in the state of California, but family homes, in order for it to qualify for the family home, the exclusion to qualify, the parent must have used the house as their principal residence for 1 year prior to death, and the child inheriting must also use the home as their principal residence for up to 1 year after they inherit or after the date of death. So there's just a lot more requirements now, and it did away with the exclusion for a lot of families who maybe, the child already has a home and they wanted to inherit this home and keep it as a rental property, or have one of their kids, move into the home. And unfortunately, that's just not available anymore. So we do see a lot more increase in the property tax basis. Slide, please. So here's just a quick example comparison here. Pre-Prop 19, the children can keep property tax basis of their parents, even if they don't live in the home. And the result was that rental properties, commercial properties, second homes, the property taxes were not reassessed most of the time. Post-Prop 19, again, the children can only keep the low property tax basis if it was the parent's principal residence and the child's principal residence. And, now it's going to basically have, the result is, forced sales of these commercial properties and rentals. So so most trusts will state, upon my death, please divide my trust estate equally among my children. I would say probably about 75% of the trusts we see that we help people administer have one home, some cash, and maybe 2 or more beneficiaries, right? Maybe they have 3 kids. So the trustee comes into this difficult decision, are we going to sell the property or are we going to distribute? And the trustee does have discretion to decide, but the beneficiaries have the right to complain about it and make objections to that. So these are some of the problems that, if somebody wants to inherit the home, these are some of the problems that can arise if we don't have enough liquidity to pay out the other beneficiaries who don't want to inherit the home. You got beneficiary disputes that can lead to litigation with, have to go to court. You got trustee deadlock. A lot of times there's 2 co-trustees and they're both beneficiaries, right? One trustee is like, I want to inherit. And the other trustee says, no, I want to sell. And then we have a trustee deadlock. We have to go to court to break the deadlock. And then forced sales, if you can't afford the property taxes because the exclusion doesn't apply, then you might have to sell that, that really high appreciating asset, that commercial building that your grandfather passed on through generations, because you can't afford the property taxes. So I wanted to offer some solutions to these problems. And the first one is really careful planning with your trust attorney. Matt puts together the estate plans, and if you have an estate plan, you want to make sure that you talk to your kids and kind of understand who may want to inherit the house. If one kid wants to inherit the house and the other person, your other child does not want to inherit the home, maybe they have their own home or live out of state. These are important things and discussions that you should have with your children and your trust attorney, and make sure that the document is written in a way that allows for beneficiary buyouts and such. Post-death loans, I covered this in my last presentation. These are like commercial loans, actually, because it's made to an irrevocable trust, which is a separate legal entity. They're really high interest rates, like 20%. So we do a lot of those with they're just this real quick bridge loan. But you can try to avoid those if you do the careful planning. And last but not least is life insurance. So if you have life insurance, which Josh is going to go into more detail on, life insurance would be, on the parent's life, and upon their death, it would be a payout either to the trust or to the children, depending on a couple different factors, mostly depending on what their sort of gross value of the estate is, right? Because we don't want to run into problems with the federal estate exemption amount or gift tax exemption amount.